If you've watched the previous 3 videos in this series, you should have a pretty good idea about what supplemental security income is and how you apply to receive it. Because the hearing is so important to your process, we asked a chief judge who has presided over such hearings to explain exactly what will be expected of you.
I am Mason Harrell. I'm Chief Judge, San Bernardino, California, Office of Disability Adjudication and Review. Today I am not speaking to you in my official capacity as a judge or as a representative of the Office of Disability Adjudication and Review, but I am speaking to you as an individual who has been a judge for 21 years and Chief Judge here at San Bernardino for 15 years. I've been asked to tell you some things about the hearing process, what a hearing is, what a judge's responsibilities are, and what your responsibilities are as a claimant. Now, your first responsibility is to decide whether you want to be represented at your hearing. You are entitled to represent yourself if you wish. You don't have to be represented by an attorney or representative. If you choose to be represented, you are responsible to find an attorney or qualified representative to represent you. The choice is yours. The Office of Disability Adjudication and Review does not endorse any firm, any law firm, or any organization which represents claimants. For most of you, your hearing will be your first chance to see and talk to the person who will be making the decision in your case. The hearing is on one hand somewhat formal, for you will be sworn in, but on the other hand it is somewhat informal. It won't be anything like what you see in court dramas. There will not be a lawyer working for the Social Security Administration who tries to prove you are not disabled. You can speak normally. No one will object to questions as you see on TV, and there will be no strict rules of evidence or procedure that must be followed. There may be experts called to testify at your hearing, medical and vocational experts. Know that medical experts are not employees of the Social Security Administration. They are asked to review your medical records and answer questions about your medical condition. Likewise, vocational experts also are not employees of the Social Security Administration. They are to answer questions about how the limitations you have might impact on your ability to work. These experts are witnesses whose testimony will be considered by the judge, but the judge is the one that will make the decision on your case. If you speak a foreign language and prefer to have the proceedings translated, a translator will be provided to you at no expense. Now, I've described what to expect at a typical disability hearing. If you decide to represent yourself, here are some important things that you need to know. First, we will send you notices about your hearing. It is very important that you read them carefully, and if they ask you to do something, you must do it. One notice will tell you when the hearing is, where it is, and who will be at the hearing. It is most important that you come to the hearing. If you fail to attend without good cause, your claim will be dismissed. If you have any new documents from medical sources that we don't know about when you filed your hearing request, it's important that you make every effort to obtain copies of these medical documents so that the judge can consider them. If you cannot get copies of these records yourself, let the hearing office know, and we'll try to help you get the records. Come to the hearing office at least 30 minutes before the hearing is scheduled to begin so that you can review your file and make sure your file contains everything you submitted after we notified you the file was ready. Submit any new medical evidence that you have received which you have not already submitted as soon as possible. You can bring to the hearing documents that you received at the last minute. You should bring your prescription medicine bottles with you, one for each medication. Even bring ones that you no longer take if they're available. You can have your own witnesses at the hearing. These should be people who have firsthand knowledge of your conditions and limitations. When you or your witness is asked a question, speak clearly, for your testimony is being recorded. Come prepared to answer questions about your age, your education, your previous jobs, your daily activities, and any disabling symptoms that you have due to your medical conditions. If your minor child is the claimant, you should be prepared to answer similar questions about your child. If you don't understand a question, say so, and the judge will be happy to rephrase it. If you need a break to use the restroom or just need a break to change the position that you're in, let the judge know and he'll be happy to accommodate that. If there is a doctor or a vocational expert present, their answers to questions may include terminology that you might not understand. If you represent yourself, know that you will have an opportunity to ask these experts questions about their testimony, including questions about any confusing terms they may have used. Now, the judge will come to the hearing prepared to ask you questions to better understand your claim. When the judge has finished questioning you, you should be prepared to tell the judge anything about your claim that you feel hasn't been covered, so that the judge can make sure that he affords you a full and a fair hearing. You will probably not receive a decision on your case the day of the hearing. After the hearing, the judge will consider the testimonies taken, the exhibits presented, and the requirements of the law, and then the judge will make a decision on your case. A written decision will be prepared and it'll be mailed to you. Because there is currently a significant backlog of cases, it may take some time for you to receive a decision. So make sure the hearing office has your correct mailing address and update it as necessary. I hope this brief overview helps you understand better the hearing process, so you can know what to expect and you will be able to fully present your case at your hearing, so you can have a full and fair hearing on your disability claim.
If you've watched the previous 4 video clips and believe you are qualified to apply for supplemental security income, you now have the information you need to move forward with the process. We've prepared one final video just to tell you a little more about Inland County's legal services. To see it, click on the video entitled Who We Are.